For admission, item 24, first appeal 162 of 1025.
Admit all for the cause from the concerned court. और उसको ऊपर लिखिएगा. Issue notice to the respondents for which requisites under speed post be filed within a period of 2 weeks from today. All for records from the concerned court. Post on. Just a minute. Post on. 8th of December, awaiting service.
Item 25, first appeal 164 of 1025.
Admit. Issue notice to the respondents. Same order कर दीजिए. Records for ordinary process and नहीं इसको speed post.
Speed post within 1 week.
Within 1 week. Within 1 week. Date से.
इतना
लंबा डेट का जरूरत नहीं. एक सेकंड. Within 1 week. Post this case on 17th. Awaiting service.
But traditionally, I'll also take 10 shaman for service to the respondent because execution proceeding has already been initiated. I was only saying that it may be kept for final disposal.
What is the execution case number?
That is the instruction I have.
Wait for something.
Okay.
उसके लिए ना आप एक पिटीशन आइए फाइल करें.
Before the next deadline. Okay.
वैसे वो एप्रियल हो ही जाएंगे मेरे ख्याल से. यहाँ जैसे ही स्पीड पोस्ट का सर्विस रिपोर्ट आ जाएगा ना, we will accept the notice as valid. And then if you file your petition for stay of the execution case, depending upon what is the nature and what is the stage, then in spite of notice, if they do not appear, you will stay there. अपने appear हो जाएंगे, right?
Okay.
For hearing under Order 41, Rule 11, item 26, second appeal 407 of 2019.
Well, in this case, my lord, I got the information. Repeat number 2, my lord, died.
Appeal number 2.
2, my lord.
When?
No, Sumat Indravati Devi.
When?
The exact date है जो लगता है आज सुबह टेलीफोन से एक लेडी उठाई बड़ा डिटेक्ट कर लिया है.
तो exact मतलब एक साल पहले.
एक साल से पहले बेसिकली.
एक साल से?
एक साल से more than एक साल से.
अबेट तो कर ही गया.
हाँ, एक साल पहले.
कब का अपील है?
अपील है 2019.
Order 41 में है.
Order 40.
Learned counsel for the appellant has submitted that the appellant number 2
जी.
has expired. About more than a year back.
More.
And he is not aware about the exact date of death. कब रखें?
After 3 weeks.
आपके पास फोन आ गया तो आप 3 वीक्स का क्या करेंगे? उसमें 2-4 लोग और मर जाएंगे.
2 weeks कर देंगे. 2 weeks.
He prays that the matter be posted on 12th November. Post on 12th November.
Item 27, second appeal 409 of 2019.
If I prayed for an adjournment in this matter, my senior has to assist the court leadership in this matter. It is not in town.
But it may be listed on after 10 because matter has been noted with Bakshi Diva, so it's out of scope because of personal difficulty now. He is coming back on 10th of November. So she has also prayed that may be listed after 10th of November.
अभी तो अपील एडमिट नहीं हुआ, उनका क्या काम है?
ठीक है, बोले कि प्रे कर देंगे. नहीं है वो अबाउट सीजन.
Hey, it's okay, but at this stage, respondent is actually not notified. Really?
Any date can be fixed after 3rd of November.
And advance notice seeking adjournment has been circulated. At the request of the learned counsel for the appellant, pose this case on 4th of November. It is made clear that no further adjournment.
Item 28, second appeal 416 of 2019.
May I please? This is plaintiff's second appeal.
What is this IF? IF? This is regarding removal of the case. Is there any IF pending?
608-2022.
Has already removed the case. ISA number 416 of 2016 with IA number 6802 of 2022. The petition was filed, the interlocutory petition was filed seeking further time to remove the defects. To comply the order dated 14/7. However, the defect has already been removed. Accordingly, IA number 6808 of 22 has become useless and hence closed. The suit was dismissed.
Suit was decreed
Okay.
against the judgment of reversal. I am the plaintiff. Suit was filed against the defendant under Rent Act for eviction of the defendant on account of default in payment of rent, bona fide personal necessity. Now, case of the plaintiff is that the suit property was originally held on possessed by one Jagu Sao, Jagu, Jagu Sao,
Sahu.
Sao, S-A-O, who died leaving behind his son Chedi Sao.
Chedi Sahu.
And Chedi Sao died leaving behind his wife and 4 sons.
Yes.
And one son of Chedi Sao is Jibodhan Sao.
G Bodhan.
Yes.
Spelling बताइए.
Jeobodhan.
Sa.
Jibodhan Sao also died, leaving behind 4 sons and his widow, namely Pati Kuar, P-A-T-I, Pati Kuar.
Yes.
Now, the suit case of the plaintiff is that suit property, there was partition between all the legal heirs of Chedi Sao, and the suit property was allotted to Virender Prasad Sao, Ramesh Sao, and Dukhni Devi. Virender Prasad Sao and Ramesh Sao are 2 sons of Chedi Sao, and Dukhni Devi is wife.
So suit property was allocated to
Two,
Ramesh.
two sons and wife.
Ramesh.
Virender Prasad Sao and Ramesh Sao and Dukhni Devi.
Ramesh Birendra.
Ramesh, Virendra and Dukhni
Dukhni Devi was
is wife of Chedi Sao. Chedi Sao is the son of Jagu Sao, only son of Jagu Sao. Now,
excellent. ये plaintiff का case है.
ये plaintiff का case है.
The learned counsel for the appellant has submitted that, as per the case of the plaintiff, the suit property belonged to Jagu Sao, whose son was Chedi Sao, and Chedi Sao died leaving behind his wife Dukhni Devi and 4 sons. Amongst the 4 sons of Chedi Sao, one was Jibodhan Sao, who also died leaving behind his wife Patti Kuwar and 4 sons. It was a specific case of the plaintiff that there was a partition amongst the legal heirs of Chedi Sao, and the suit property was allocated to Ramesh Sao, Virender Sao, both sons of Chedi Sao,
My lord.
and to Dukhni Devi, wife of Chedi Sao.
My lord. Now, these 3 persons, Ramesh, Virendra and Dukhni, they transferred the suit property to one Jaitun Nisa by virtue of registered deed of sale dated 21/4/1989.
Jaitu Nisa.
Yes.
Jaitu.
Jahan.
Nishan.
My lord.
Registered.
Jinatun, I'm sorry, Jinatun, Jinatun, Jinatun Nisha, Jinatun.
Jinatun
Nisa.
Nisa. Registered sale.
Yes, by virtue of registered sale deed dated 21/4/1989.
21/4/1989. He submits that Ramesh Sao, Virendra Sao, and Dukhni Devi, Dukhni है ना?
My lord.
Dukhni Devi jointly sold the suit property to one Jinatun Nisa, Jinatun by virtue of registered sale deed dated 21/4/1989.
Now this purchaser, Jinatun Nisa, also sold and transferred the suit property to the plaintiff by virtue of registered deed of sale dated 8/8/1990.
Which was then sold by Janatun Nisa to the plaintiff by virtue of registered sale deed dated 8/8/1990. The plaintiff came in possession of the suit.
Yes. Now the defendant name is Om Prakash Saw. Om Prakash Saw. He is son of G. Bodhan Saw. G. Bodhan Saw was son of Jechedi Saw. And
Yes.
there was further specific pleading that one suit was filed for against Jinatun Nisa, title suit number 58 of 1990. Now,
Om Prakash Shah is defendant number 1.
Om Prakash Saw is defendant.
Only
Only one, yes. Now,
The
let us
sole
write-
defendant, Om Prakash Saw,
yes.
is son of Geobodhan Saw. Okay?
Now, only one correction, my lord. There is fault on my part, my lord. The suit property was partitioned between Chedi Saab and all his sons and the legal heirs of the deceased Jibodhan Saab. I may be permitted to stand corrected.
उसमें तो amongst तो नहीं बोले.
नहीं बोलेंगे, लेकिन क्योंकि छेदी साहब जो एक है वो भी पार्टी थे उसमें.
The learned counsel has submitted that वो भी part, छेदी साहब भी party.
हाँ, फिर उस पार्टीशन में
The
छेदी साहब
learned
भी
counsel has submitted that in the previous partition, Chedi Saw himself was a
पार्टी.
party, and the property and the entire property of Chedi Saw was partitioned amongst
और
his sons, including Geobodhan.
well, including legal heirs of Jibodhan, because Jibodhan was also dead.
Including legal heirs of Geobodhan Saw,
Yes.
since Geobodhan had expired prior to Chedi Saw.
Well, now one suit, well, title suit number 58 of 1990 was filed by against Jinatun Nisa.
Who filed it?
This suit was filed by Chedi Saab and one another person, Chedi Saab and Nageshwar Saab, one of the son. Two persons filed suit, my lord. Chedi Saab and Nageshwar Saab.
Whose son?
So, Nageshwar Saab is son of Chedi Saab.
The learned counsel submits that one title suit number 58 of 1990 was filed by Chedi Saw and his son,
Right.
namely Nageshwar Saw,
Yes,
against Jainatun Nisha
yes.
in connection with the suit property involved in this case.
And for declaring that the sale deed dated 21, registered sale deed dated 21 for
Seeking a
1989.
declaration that the registered sale deed number 20, registered sale deed dated 21/4/1989, transferring the property
is ab initio void.
by Ramesh, Virendra and
Dukhni.
Dukhni to Jaitu Nisha is void ab initio.
Yes. Now this suit, Jinatun appeared, and in that suit, sale deed was challenged, suit was dismissed.
The learned counsel submits that the title suit number 58 of 1990 was dismissed.
Now, in that suit, both the parties filed their pleadings, and there was a specific finding of the learned trial court that this is admitted case of the parties, that there is partition amongst all. It was recorded.
The
Now,
learned counsel has submitted that the title suit number 58 of 1990 was dismissed primarily on the ground that there was already a partition amongst Chedi Saw and his legal heirs and successors.
Now, thereafter, this Om Prakash Saw, who was also one of grandson of Cherisa, he was inducted as a tenant not in the year 2002. He was inducted as
That's
by
paramedic. The learned counsel for the appellant has submitted that Om Prakash Saw, son of Dubodhan Saw and grandson of Chedi Saw,
yes,
was inducted as a tenant in the suite premises.
yes. Now the tenancy was oral and
By
With-
oral tenancy,
yes. Now my lord, they paid rent, my lord, till August 2002.
and rent was paid by Om Prakash Saw
To this person, my lord, the plaintiff.
plaintiff का क्या नाम है?
प्लेंटिफ का नाम है फातिमा बीबी। फातिमा बीबी जो परचेज की जिनातुन से।
To Fatima Devi,
Bibi.
Fatima Bibi, who had purchased the suit property from Janatun Nisa by registered sale deed
Yes.
dated 8/8/1990.
Yes. So there was two ground. One was default in making payment of rent, and second was personal necessity, because son of the plaintiff had started legal practice, so he was in need of house for the purpose of his residence and chamber. It was specifically pleaded in the plaint.
The learned counsel submits that the suit was filed on account of default in payment of rent and also personal necessity, inasmuch as the son of Fatima Bibi became a practicing advocate, became an advocate, and he needed the suit property for his residence and chamber.
Now, thereafter defendant appeared, he filed written statement and admitted that the property is owned by Jagus because he was the grandson of Chedisa. He also admitted that yes, Chedisa had 4 sons, Dukni, his wife, but defendant denied that there was partition. Defendant said no, there was no partition, and I am also one of the co-owner of the suit property. I am not the tenant.
The learned counsel submits that the defendant appeared and admitted the genealogy, right?
Yes, yes.
Admitted the genealogy and also but denied that there has been any partition with respect to the suit property.
Yes.
And on account of absence of any partition, he asserted himself to be a co-owner of the suit property and thus denied the relationship of landlord and tenant
Okay.
between the parties.
So on the basis of these rival contention, issues were framed. Altogether 6 issues were framed. 2 issues was important. Issue number 3 was in relation to relationship of landlord and tenant, and issue number 4 whether the defendant can be evicted on the ground of default and such.
The learned counsel submits that on these rival contentions, the issues were framed and issue number framed as follows. Quote karna hai.
Para number 4 of the trial.
Para 4 of the trial court judgment. He has further submitted that issue number 3 and 4.
3, only 3 is the relationship.
The issue number 3 related to relationship of landlord and tenant, and issue number 4,
And 5 is regarding
4
the,
and 5 was relating to default in payment of rent
and personal necessity.
and personal necessity respectively.
Yes. Now, my lord, the plaintiff filed the judgment of the suit, title suit 58 of 1990. It was exhibited on as Exhibit 8.
The learned counsel submits that the plaintiff had exhibited the judgment passed in title suit number
Paragraph 5
58 of 1990, which was marked as Exhibit 5,
Eight.
sorry, Exhibit 8,
Yes.
and its discussion is reflected from paragraph number
My lord. Paragraph 11.
paragraph 11 of the trial court judgment.
Yes, no, my lord, reflected, I'm sorry, my lord. Paragraph 5, my lord, will find of the trial court judgment.
Paragraph 5 of the trial court judgment, and has also
Also, my lord, adduced, my lord, order of the title appeal against that suit, appeal was preferred, and appeal was also dismissed for default.
he has also submitted that the title suit was subject matter of title appeal number. The judgment passed in title suit number 58 of 1990 was subject matter of title appeal number 41 of 1993, and the appeal was also dismissed.
Yes. Now, my lord,
The learned counsel submits that in such circumstances, the transfer made by Ramesh, Virendra and Dugni Devi to Janatu Nisha by registered sale deed number 20, registered sale deed dated 21/4/1989 became valid and had become valid and binding on the parties by virtue of the judgment passed in title suit number 58 of 1990 and against which the appeal was also dismissed. यही बोलना चाह रहे हैं?
yes, yes, yes.
ठीक है, और बताइए.
Thereafter, my lord, the learned trial court, my lord, after going through the taking into consideration the evidence of PW1, PW3, and PW9, it came to a specific finding that there is relationship of landlord and tenant between the parties.
PWs.
Yes, my lord. Plaintiff हम थे, plaintiff का.
The learned counsel submits that the learned trial court considered the evidence of PW1, 3 and 9 and has come to a specific finding that there was a relationship of landlord and tenant between the parties.
The learned trial court, my lord, in para 14, learned trial court has also taken note of evidence of this defendant who was examined as DW3 and regarding his cross examination. He was asked a specific query that whether he filed any suit for cancellation of the sale deed of Jaitu Nisha or the plaintiff, or whether he know about the title suit of 1990. He stated that no, I have not filed any suit, and he has also said, my lord, that he does not know regarding the title suit of 58 of 1990.
This is DW number.
DW3, paragraph 14 of the trial court judgment, it has been
The
recorded.
learned counsel have also submitted that the learned trial court, while considering the aforesaid issues, has also referred to the evidence of DW3, who had categorically stated, who had expressed his unawareness in connection with title suit number 58 of 1990 and the judgment and decree passed in the same case.
And he has also admitted that he has not filed any suit to cancel the sale deed of Jaitu Nisha.
He also admitted, he also stated that he had not filed any suit seeking cancellation of the registered sale deed with respect to the suit property in favor of Janatu Nisha. That's it.
Yes, ma'am. Now, my lord, suit was decreed. The defendant preferred appeal. Title appeal, my lord. Civil appeal, which was numbered as, my lord. Civil appeal number, my lord, 29 of 2018.
2018.
Yes, sir.
2018.
Yes, sir. 19 of 29 of 2018. Civil appeal number 29 of 2018.
सूट का क्या होगा?
सूट मेरा सूट डिग्री हो गया and it has been held that there is relationship of landlord and tenant between the plaintiff and the
The
defendant?
learned counsel submits that the trial court decreed the suit after holding that there was a relationship of landlord and tenant between the parties, against which an appeal was filed in title appeal number 29 of 2018, which is subject matter of the present case.
Well, now,
Appellate court can-
yes, now in the appeal, the learned first appellate court has given a very perverse finding, holding that no, the plaintiff has failed to prove there was partition amongst the heirs of Jagusa.
The learned counsel submits that the learned first appellate court, while setting aside the judgment passed by the learned trial court, was of the view that the plaintiff had failed to prove
Prove the claim of partition allegedly,
the claim of partition
allegedly took place among the heirs of Jagusa. Internal page 13 of
which allegedly took place amongst the heirs of
Jagusa.
Jagusa.
Now there is, and further held that there is absolutely no evidence. Now,
And held that there was no evidence
yes.
with respect to such partition.
And well, thereafter decided that defendant is the co-owner and there is no relationship of landlord and tenant because,
And
yes,
the learned first appellate court, as a sequel to their first finding, was of the view that the defendant was
not a tenant.
the co-owner of the suit property and was not a tenant in the property.
Yes. Because every plaintiff's witness was cross-examined on this point, that whether defendant grandfather was owner of the property, whether the other person was as a co-owner. So evidently they were the co-owners. So it was accepted. Now, my lord, I have, my lord, the certified copy of this judgment also. So the learned trial appellate court, my lord, has given a perverse finding, my lord, regarding issue of partition, that there was issue of partition, and moreover there is in a case of eviction, my lord is well aware that the necessary issues are whether there is a relationship of landlord and tenant or not, and whether the landlord has proved the grounds for default. So, my lord, there was sufficient oral evidences, my lord, who have proved that there was tenancy. There was even documentary evidence, my lord, that which proves that there was partition. My lord, I have also brought the certified copy of that title suit number 58 of 1990, my lord. Paragraph 11 is very clear. It has been held by the earlier court. It is admitted case by both the parties that there was a partition.
And this Jagusa was a party.
Jagusa was the Chedisa.
Jharkhand was a party.
No, Jibodhan Saw was not a party, and but he has stated that I have not filed any suit for cancellation.
That is a separate thing.
Yes.
He had not filed.
No,
any
he was
suit.
not a party.
He was not a party.
Not a party.
He had not filed any
No.
case.
But other co-owners came in that suit, my lord, and they were examined, and thereafter this
But how will it bind the plaintiff?
plaintiff bind
How will he bind the defendant?
defendant will bind by
Because
he was claiming through Chedisa.
He was claiming through Chedisa.
He was grandson of Chedisa.
There was a partition amongst whom? Who were the parties in the partition?
Partition among Chedisa
And
and his sons,
sons means Jharkhand.
Jibodhan. Heirs of Jibodhan. Heirs of Jibodhan. And in that suit was filed by Chedisa. Now the question is, in a suit for eviction on the ground of default and personal necessity, the mandatory adjudication was relationship of landlord and tenant. And once there was, my lord may kindly take the trial court judgment, there was a specific quoting of particular plaintiff's witness who has said what has said, everything has been recorded. The learned trial court came to a finding, no, the plaintiff has failed to prove any partition, any documentary evidence which could suggest that there was partition. And my lord, the learned trial court has held that he was the one of the co-owners. So in a suit for eviction on the ground of default and personal necessity, my lord, incidentally it can be touched But my lord, it cannot be dismissed on the ground that there was partition or not partition. Rather, there were other evidences also, my lord, which shows that there was partition.
The learned counsel has submitted that the learned first appellate court has completely failed to appreciate that there was enough material on record to show that there was previous partition, including the judgment passed in title suit number 58 of 1990. Is there any finding that there was a previous partition in this
Yes,
case?
yes, there is a finding, that's why, my lord. Yes.
The learned counsel has submitted that the learned court has misconstrued Exhibit 8. The learned first appellate court has not considered the import of Exhibit 8. Exhibit 8 consider किया?
नहीं, it has not been considered. Kindly see, my lord, you will see, my lord, the finding starts from internal page 9 of the trial court's judgment. Issue number, is there any relationship of internal page 9 of the first appellate court's judgment? My lord has got it. Now, my lord, I read entire, my lord. This is the main point of the case. In this context, first of all, I want to refer the observation of the Honorable Court. In the case of such and such, reported in Honorable Court has pleased to observe that landlord in such a such
Page number कौन सा part?
page number, internal page number, my lord, 9 of the first appellate court judgment. Appeal वाले में.
This is the main point.
Yes. In such a suit, is required to prove only two things to enable him to claim a decree for eviction against his tenant from the tenanted suit premises. First, there exists a relationship of landlord and tenant between the plaintiff and the defendant. And second, the ground on which the plaintiff landlord has served defendant's tenant's eviction under the Rent Act exists. With these two things, when these two things are proved, eviction suit succeeds. It has been further observed by the Honorable Court that the question of title to the suit property is not germane for the decision of the eviction suit. The reason being, if the landlord fails to prove his title to the suit property, but proves the existence of relationship of landlord and tenant in relation to the suit premises and further proves existence of any ground on which the eviction is sought under the Tenancy Act, the eviction suit succeeds. Conversely, if the landlord proves his title to the suit premises but fails to prove the existence of relationship of the landlord and tenant in relation to the suit premises, the eviction suit fails. At last, the Honorable Court pleased to observe that in the eviction suit, the question of title or the extent of the shares held by the appellant and respondent number 1 against each other in suit premises cannot be decided, nor can be made the subject matter for its determination. Coming back to the present case, I find that admittedly the suit property was earlier owned by Jaggu Saab, the grandfather of the defendant. The plaintiff claims that a partition took place among the heir of Jaggu Saab, in which one half portion of the suit property was allotted to his son Sadi Saab, Ganesh Saab, and so, and heirs of Jivgodhan Saab, and other half portion was allotted to Birendra Saab, Ramesh Saab, and Dukhni Devi. And through a transfer by way of registered sale, plaintiff obtained the one half portion of Birendra Saab, Ramesh Saab, and Dukhni Devi. First of all, I find, my lord will God, this is important, that plaintiff has failed to prove the claim of partition allegedly took place among the heirs of Jaggu Saab. This finding is perverse.
नहीं इसका कोई रेलेवेंस नहीं है
नहीं है वो तो नहीं
इसका इसलिए रेलेवेंस नहीं है was there a partition amongst the legal heirs of Chedi Saab? This is relevant.
This is relevant.
Because Chedi Saab had number of sons.
Yes.
Out of them, only some of the legal heirs had sold the property.
Yes.
Right?
Yes. And in the sale deed, there was the sector. Apart from there, that sale deed was challenged by one of the two possessors, Chedi Saab and one son challenged the sale deed of Jinatun Nisa. Challenged this sale deed. Same property was in question in earlier suit. Now, apart from it, my lord, why? Because I am saying that the finding of the trial court that there is absolutely no evidence, either documentary or oral, on record regarding this part of the plaintiff. Now, thereafter, my lord, and there is no doubt.
You see, there is no relevance of
Partition
of
even also,
judges.
even also,
Yes, so
if-
how does
yes.
that make it?
No, why I am saying, my lord, because there was a finding, and this was my duty, my lord, to say exact picture of the suit and appeal. Now, thereafter, my lords will find, so far as claim of tenancy is concerned, admittedly, no written proof exists of the same, and hence, only oral evidence is there for consideration, and as such, the quality of evidence to prove the tenancy, in other words, the relationship of landlord and tenant is required of a high degree. Out of total 6 witnesses of the plaintiff, P1, PW1 and 2 are formal one, and out of rest 4, 2 are sons and husband, respectively of the plaintiff. The plaintiff describes the boundaries such as such. Thereafter, kindly next page. PW3, although claimed that his own house is situated in western side of the disputed house where he resides along with his family, but his said claim does not find support either by plaintiff or by any other witness. I take pause, my lord. My lord, can you take this one, page number 11?
Second appeal में इतना नहीं सुनेंगे ना?
नहीं, हम क्या कहना चाह रहे हैं कि trial court has said that I will not give any importance to oral evidence. Why? Because the evidence is not pleaded in the plaint. Kindly see the PW third line. The PW3, although claimed that his own house is situated in western side of the disputed house where he resides along with his family, but his said claim does not find support either by the plaintiff or any other witness. Now, my lord, I take pause. Kindly take, my lord, trial court judgment. Kindly take.
He failed to describe the suit property also. He had nothing.
No, he has said. He has said. My lord, now kindly take internal page 13 of the trial court judgment. What appellate court has said, my lord? Appellate court has, yes,
To this extent, where he was deciding is not relevant.
not relevant. Now the question was only that whether he was one of the evidence to prove relationship of landlord or tenant. The trial court has taken same evidence, same witness, and he said, yes, there was tenancy. The landlord has given the suit property on rent, but the appellate court has, my lord, has not given any reasoning. What reasoning is given? That since there was no document to support evidence of partition, the evidence of PW3 is not written in the plaint. My lord, whether evidence are required to be pleaded in the plaint. Kindly take, my lord.
No, please don't pick up a sentence from.
No, thereafter, my lord, kindly see, my lord. Kindly see a further evidence, my lord. My lord, kindly take other PW4 and other PW5. PW4, my lord, kindly see a PW4.
No, you are not able to channelize your argument. आप ऐसे नहीं आप your most important argument was that this judgment was not taken care of and the persons were parties to this proceeding. So, right? Who were parties to this proceeding?
Parties to the
Proceeding, the suit,
this suit.
the previous suit.
Previous suit, my lord, Chedi sir. He was father, my lord, kindly appreciate. My lord, kindly go through the, my lord, the own noting, my lord, where Chedi sir was son, father. And there was partition between Chedi sir, his wife, and other legal heirs. Now, said deed of Jinatu Nisa was challenged by Chedi sir and one son. And in that suit, on behalf of plaintiff Chedi sir and one sons, other co-heirs came, except my vendor. they came and said that there was no partition. But thereafter,
So that judgment will not bind your vendor, no?
no, that will bind.
No, it will not bind this tenant, because tenant or the tenant was not a party in that proceeding, isn't it? Although he claimed to be a co-sharer, but he was not a party to this partition suit.
Partition suit,
This
title
title
suit.
suit, yes.
Now, my lord, if it was so, my lord, whether the first appellate court should not examine, my lord, exhibit 8 and 9, my lord, whether the judgment passed by the learned first appellate court is perverse on account of non-consideration of exhibit. Had
No,
it,
it becomes perverse only if it has a bearing.
it has bearing, my lord, because they were examined, they appeared as a witnesses.
Who appeared as a witness?
My lord, the other family members of Chedisa. Just, my lord, I will just answer this, my lord. Just, my lord, kindly grant me some time. I am sorry. I will soon. So even if, my lord, because he was not a party, now if my lord saying, my lord, that this cannot be considered. Now, my lord, kindly take the evidences which proves the relationship of landlord and tenant. Because there was a specific finding of the trial court. Kindly take, my lord, the judgment of trial court. Because, my lord, had it been a case that the appellant, plaintiff was not purchaser, plaintiff was purchaser by virtue of registered deed of sale. Now his sale deed was not challenged. Now, my lord, kindly see the trial court findings, my lord. Kindly see, my lord. My lord, internal page 13, if my lord allow me.
Rent receipts were exhibited. Payment of rent is proved.
Payment of rent has been proved, my lord, by oral witnesses.
Is there any finding of payment of rent?
Yes, my lord, yes. There is a finding of the trial court. Internal page, that why I want to refer, my lord. Internal page 13, my lord. Payment of, my lord, will find the lowest paragraph.
Yes.
That internal page 13, lowest paragraph.
Further it is established.
Yes.
What is this exhibit 1, 2, 3, 8 and 9?
My lord, this exhibit 1, 2, 3, these are the, my lord, say deed 8 was
Where is the finding of payment of rent?
payment of, my lord, this one, my lord, all witnesses of this is the finding, heard the learned lawyers of the parties and peruse the record very carefully, my lord, got this line. Heard the learned lawyers of the party and peruse the record very carefully as per the plaintiff. As per the plaintiff, PW3, PW4, PW5 and PW6 of their respective deposition have supported the above pleadings of the plaintiff. All witnesses of the plaintiff have supported the case of the plaintiff, especially PW3 and PW4, who are independent witnesses, have categorically stated that plaintiff has given the suit house 3-room dhaba at rate of 300 rupees per month to defendant on 1/6/2002 and they were present at the time of rent agreement of the said house. and the defense of defendant is disputing the ownership of property but fails to establish as his property, whereas plaintiff has all the papers related to disputed land. Further, it is also
Where is the agreement? Agreement has been executed
no, rent act, there was oral agreement. There was oral agreement.
at the time of rent agreement.
Yes. It is also concluded that plaintiff has well established orally that defendant is residing as tenant in the property of the plaintiff. So there is a specific finding of the trial court. Now, my lord is also aware with regard to the provision contained in section 116 of Evidence Act, my lord. If any tenant, my lord, says no, he has no, my landlord is not my owner, then my lord, he cannot say so. And my lord, he has to first surrender the tenancy and thereafter he has to claim a suit, my lord. And that's why, my lord, I have referred, my lord, kindly see the specific cross-examination of defendant was taken note of the trial court, my lord, in internal page 12, my lord. In cross-examination, he has specifically admitted that he has not filed any civil suit to cancel the salary of Jaitunisa. Internal page 12.
Why should he file a suit? He's already in possession. He's already in possession.
He is already
He is already in possession, and you have not filed any eviction suit on account of any ground other than tenancy.
Well, only difficulty with the plaintiff that the plaintiff has given his property to a person who was in genealogy of the actual owner. Now, my lord, only whether, my lord, the
A regular suit, you see, under such circumstances, a regular suit, there is a lot involved in this. Even private facie finding of title could not happen together. Very difficult.
I am not saying because finding of title cannot be given in every. I do
Even
agree.
in order to come to a landlord-tenant relationship, to some extent title can be seen, but not in such an intricate case.
So that is their matter. But whether oral evidence can be brushed aside, whether once I adduce one, if I have given any property, my lord, either this is, my lord will try to understand, this is a case of the year 1990. My lord, at that relevant point of time, my lord, generally, my lord, what tenancy was created. And if I brought those evidences, my lord, who said that yes, we were present, we are the oral witness, whether oral evidence has no relevance. Whether oral evidence is no relevance at all, my lord.
You read the finding of the trial court. You heard. Yes.
Yes.
You are convinced.
Heard the learned lawyers of the parties and peruse the record very carefully. As per the claim, the PW3, PW4, PW5 and PW6 of their respective deposition have supported the above pleadings of the plaintiff. All witnesses of the plaintiff have supported the case of the plaintiff, especially PW3 and PW4, who are the independent witnesses have categorically stated that plaintiff has given the suit house 3-room dhaba at a rate of ₹300 per month to defendant on 1/6/2002, and they were present at the time of rent agreement of the said house. And the defense of the defendant is disputing the ownership of property but fails to establish as his property, whereas plaintiff has all the papers related to disputed land. further it is well established that by the plaintiff that she is the owner of the suit property by exhibited document, exhibit 1, 2, 3, 8 and 9. It is also concluded that the plaintiff has well established orally that the defendant is residing as tenant in the property of the plaintiff. It is also concluded that disputed land is of the plaintiff as she has sale deed, rent receipt, title deed of her vendor, whereas the defendant have no paper except rent receipts, and thus it is concluded that plaintiff is the owner of the said land. It also appears from the judgment of title suit 58 of 1990, exhibit 4, that the northern portion was in portion of entire land and was in possession of Jinatun Nisha, and as such recovery of possession has been sought, which also proved that Jinatun Nisha through registered sale deed dated Itna acquired right, title and possession over the suit land, and thereafter plaintiff got right, title and possession over the suit house through registered sale deed number 9233 dated 8/90/90. There is no evidence to contradict the pleading of the plaintiff. Hence, from the above facts and circumstances, it can be safely inferred that there is a relationship of landlord and tenant in between the party to this suit. It is also the case of the plaintiff that her son, so and so, work as advocate at Jharkhand and he has need of the said suit house for his residence and office. Hence, the plaintiff has bona fide need of suit premises for residence and office of her son. In view of the above facts and circumstances of the case, and also from the discussions made above, the court comes to a conclusion that there is a relationship of landlord and tenant in between the parties to the suit, and the plaintiff reasonably and in good faith required the suit premises for her son for residence and office. Accordingly, these issues are decided in favor of the plaintiff and against the defendant.
The mother, the son was examined, plaintiff was examined
Yes,
as PW.
the plaintiff's son was examined and his
The plaintiff was examined as PW.
plaintiff's husband has been examined. Plaintiff
She has
husband,
not been examined.
plaintiff husband has been examined and son has been examined. Plaintiff has not been examined. Husband of plaintiff is PW6, Mohammed Ansari.
PW5, who is a son,
Yes.
he admitted that he did not know as to whether any written tenancy deed was made or not.
It was not.
Plus, he also admitted that his mother had not issued any rent receipt to the tenant.
So, my lord, he was in the year 2000, the rate it was given on rent.
PW6, who is the husband of the
Well,
plaintiff
he
and
was-
key player of the present case, failed to say the exact business
Yes.
of the defendant.
My lord, he was
They had
very
no
fair.
idea to what use the property was given.
Go down, it was go down, it was specific, but in go down what is kept, for what purpose, he has failed to say. My lord, he could lie, my lord, and say that yes, I have seen the rent receipt. But since it was oral tenancy, that's why, my lord, in cross examination, it was stated.
You see, both the parties had their evidences. Even the DW1 has supported who is the neighbor, right? He has also supported the case of the defendant. It involves adjudication on title, not a case for landlord.
My lord, that is true, my lord, but if there is oral, then my lord only,
No, oral evidences have been considered by the learned first time.
no.
Yes.
What first appellate has court discarded oral evidence on the ground that it was not pleaded in the plea first and second. My lord, kindly see.
No, that is not the only reason. You just see the discussion of oral evidence.
My lord, one
Page number
peek
11.
My lord, kindly see. Peek and choose only one line.
Only one line.
My lord, whether the oral evidence, if there was material
आप
or
बताइए ना कौन सा oral evidence?
My
You
lord,
see, both the parties have given oral evidences in their support. Both the parties have given oral evidences in their support.
just my lord, I will show you. My lord. Now, kindly see, my lord, page number internal. My lord, what is see the while reversing the judgment of the trial court, what reasons have been given? Kindly see the PW6 का disbelief क्या बोल करके कि my lord, kindly see internal page, my lord, 11 of the first appellate court judgment. My lord. PW6, who is the husband of the plaintiff and key player of the present case, failed to say the exact business of the defendant. Kindly see, my lord, it is relevant to mention that as per the pleading of the plaintiff, the defendant had obtained the pursuit premises for the purpose of Goda. Only because that the one of the witness has not said exact business, my lord, my evidence has been discredited. My lord, what was the material evidence? Material evidence was whether there was tenancy between the parties or whether what was the business of the parties. My lord, the learned first appellate court, while sitting at first appellate court, has to examine the evidence of all the oral witnesses, my lord, very carefully. My lord, may call for the oral witnesses, my lord, evidence may be called for, my lord. PW5 का एविडेंस को डिस्कार्ड किए इस ग्राउंड पे कि ही हैज एडमिटेड दैट हिज मदर हैज नॉट इशूड एनी रिसीट ऑफ रेंट. तो अगर PW5 का PW6 का इसी ग्राउंड पे हो जाएगा, देन my lord, in any case any landlord will not be able to my lord take back the property. There is direct decision of the Honorable Apex Court, my lord, reported in 2015 in case of Tapas Kumar Gupta, my lord, versus State of West Bengal, where the Honorable Apex Court, my lord, after taking into consideration only oral evidence, only oral witnesses, my lord, has decreed a suit for eviction. And my lord will find how it has been treated by the First Appellate Court. First Appellate Court has started the my lord adjudication with one finding that there is no document of partition which could prove that there was partition. My lord, all the Exhibit 8, Exhibit 9 has not at all even gone through. Both the learned First Appellate Court has not taken pain to consider Exhibit 8 and 9. अगर एग्जिबिट 8 और 9 को कंसीडर करके कह देते कि नहीं ये हो है, मतलब देन आई हैव अ डिफरेंट केस. Now, kindly take the first line of internal page 12, 11 of page number 13 of the minor, internal page 11 of the first appellate process. Not a single witness of boundary of the school property has been examined.
It is in substantial question.
My lord, substantial question number 4, Roman 4. So, my lord, and issue substantial question number 9.
Essay number 416 of 2019. The learned counsel for the appellant has submitted that the improved judgment is a judgment of reversal arising out of eviction suit number 1 of the property. He has submitted that the suit was decreed and the first appellate court has reversed the judgment and decree. He submits that the plaintiff is the appellant before this court who claimed to be the owner of the suit property by virtue of registered deed executed by Ramesh, Virendra and Rukmini Devi in favor of the plaintiff. Ramesh, Virendra and Rukmini Devi in favor of Jaitu Nisa by registered safety number 21.4.1989 and then to the plaintiff by registered safety number 8.8.99. The learned counsel has submitted that though there was no documentary evidence in connection with landlord-tenant relationship, but it was sufficiently proved through oral evidence. He has submitted that the learned first appellate court held that the defendant was a co-owner of the suit property, being the legal heir and successor of being one of the legal heir and successor of Jagusau, and one of the sons of Gyobodansa. The learned counsel has also submitted that the previous suit being title suit number
Title suit number 58 of 1990.
58 of 1990 has also not been properly considered by the learned. Learned first appellate court by reversing the judgment and the decision. The partition was by registered deed.
No, partition was not by partition.
The learned counsel has submitted that there was enough oral evidence to prove the relationship of landlord and tenant. He has submitted that the deposition of, you are referring to the deposition of DW7 and DW8 of the previous suit.
Yes,
They had said that there was a tenant over the property.
नहीं वो प्रीवियस इसका कर रहे थे PW3 and PW3 उसको रेफर
नहीं, आप रोमन 9 में तो DW7 DW8 of the title suit आप रेफर
नहीं वो मतलब DW2 है जो वाइफ ऑफ छेदी साहब है उस प्रीवियस सूट में शी हैज स्टेटेड दैट देयर इज पार्टीशन टाइटल सूट 58 ऑफ 1990 में उसमें DW2 है वाइफ ऑफ छेदी साहब शी हैज स्टेटेड दैट द सूट प्रॉपर्टी वाज पार्टीशन 7 years बैक
अब कौन सा क्वेश्चन आप और
मतलब दिस ओनली लिमिटेड टू मिलर substantial question number 4
The learned counsel has referred to the substantial question of law number 4.
and Roman 9
रोमन 9 में तो आप बोल रहे हैं आप
वो
कौन
गलत है मतलब वो गलत है इसीलिए बोले कि DW2 है मतलब में DW2 है,
7 and 8
8 लिखा गया है, वो DW2 है, DW2 है, क्योंकि
ऐसे नहीं बना सकते हैं ना।
Only
ऐसे
one-
error कहाँ से मिरर ये DW7 को हम DW2 कैसे पढ़ेंगे?
नहीं ठीक है मैडम, ओनली उस पे कर दिया जाए, केवल सबस्टेंशियल क्वेश्चन नंबर 4
has referred to substantial question of law number 4 as suggested in the memo of opinion. Considering the submission, the subpoena is edited for final hearing on the following substantial question of law. Whether the first appellate court has committed perversity in appreciating the evidence of PW3 and 4 while concluding that there was no relationship of landlord and tenant between the parties. Copy
मैडम
issue notice to the respondent. The sole respondent for the requisites under the speed post and for these requisites under speed post we filed within a period of 1 week. All from the records from the concerned court. Post this case on the 4th of November.
Item 29, second appeal 424 of 2019.
adjournment से लिखती है notes. Appellate 2 weeks time. Lords. In this case, Mr. Sumit Kumar has to argue this case. Lords. He
First
will,
one,
Mr. Sumit Kumar. Lords.
Sumit Kumar. कौन है?
He is junior to my senior. Lords. Mr. Anand Kumar senior. He went to Chennai Lords for treatment of his mother. Lords. Only paying only 2 weeks time. Lords.
कोई और आदमी ना करे अगला दिन
नहीं अगले ट्रीटमेंट कर देंगे. Lords.
कौन सा दिन
2 सप्ताह के बाद किसी दिन रख दीजिए. Lords.
सुमित कुमार आदमी करेंगे ना
हाँ बिल्कुल.
कब रखना है
2 सप्ताह के बाद किसी दिन रख दीजिए. Lords.
ऐसे नंबर 429 of 2019 the learned counsel for the applicant has submitted that the matter has to be argued by Mr. Sumit Kumar advocate who has gone out of station for treatment of his
Lords.
mother. At his request, the matter is directed to be posted on 12th of November.
Okay.
Adjournment slip मत दे दीजिएगा
नहीं
Like you
अभी
have last with that.
Lords. Okay.
From notified case for judgment item 1, first appeal 44 of 2023.
This appeal is dismissed.
From tail list for orders item 13, second appeal 178 of 2009.
Why is it district court orders?
My lord, there are 3 ideas. Claim number 280, claim number 6425 and 6424. My lord, the idea 280 is
For what?
concerned for deleting the name of respondent number 11, whose legal heirs are already on the court, that is respondent number 6 to 10.
Sorry?
No objection, Lord.
I number 280 of 2025 in second appeal number 178 of 2009. The learned counsel for the appellant has submitted that the petition has been filed for deleting the name of the fund number 11 from the cost item, who has expired on 22/12/2024, as the legal years and as her legal years and successors are already on record. Counsel for the respondent has no objection to the plea. Accordingly, RA number 280 of 2025 is hereby allowed. Counsel for the appellant is directed to delete the name of legal years and successors of delete the respond number 11 from the cost item. 6 to 10 are already on record. एक आदमी ज्यादा
Six to 10 are 5.
काउंट करिए 6 7 8 9
Six.
11
Six.
6 7 8 9 10 11 ऐसे सपाना खाते हैं इसमें सब पार्टी है कि नहीं
सबाना खातून पार्टी नहीं है।
जैरुल निसा है जुबेदा खातून है
रसीदा खातून डाइट।
शहनाज ये कौन है शहनाज परवीन ये भी है असगर भी है लेकिन सबाना खातून तो नहीं
नहीं
ये कहाँ से आ गए बाकी तो सारे बच्चे हैं इनके
रिस्टोरेंट नंबर 11
6 के ये सबाना खातून डॉटर ऑफ ये कहाँ से आ गए जरूर मियां From where has she come? बताइए
इसको आज हम प्लेस नहीं कर इसको आज हम नहीं प्लेस कर रिमेनिंग हुआ है आई एम प्लेसिंग दैट इज आई नंबर
वेस्ट करते हैं ना टाइम हम लोग का
जरूर नहीं आते यहाँ पार्टी भी नहीं होगी
वेस्ट करते हैं ना हम लोग का टाइम तो ये जब बनाते हैं तो दिखता नहीं है क्या वेर इज सवाना खातून
जहूर मियाँ रिस्पोंडेंट नंबर 1 रिस्पोंडेंट नंबर 1
उनका तो सब्स्टिट्यूशन हो चुका है ऑलरेडी इसमें तो सवाना खातून इज ऑलरेडी देयर 1E
सवाना यस यस
तो फिर ये तो गलती से हो गया ना
ये टाइपोग्राफिकल एरर होगा वो ये सवाना खातून
है ना? देखिए टाइपोग्राफिकल एरर है काटिए उसको
इसको हम आई विल मेक नेसेसरी
देखिएगा respondent numbers 6 to 10 are already on record. He submits that the name of Savannah Khatun, daughter of Jharkhand Mia, has been wrongly included in paragraph 5 and seeks and is permitted to delete the name of Savannah Khatun from the list of legal heirs and successors of respondent. Counsel for the respondents have no objection so far as the prayer for substitution is concerned. And they do not dispute that the respondent 6 to 10 are already on record. Who are legal heirs and successors of respondent. Considering the opposite submission, IE number 280 of 2025 is hereby allowed. The counsel for the appellant is directed to delete the name of respondent number 11 to the past title as his legal years and successors, that is respondent number 6 to 10 are already on record. दूसरा आइए
दूसरा आगे 6424 में for substitution of respondent number 14D. His legal years has been mentioned at RS6. He died on 24/3/2023.
6424.
14D.
Limitation.
There is a limitation of 28 days in filing substitution petition.
Who died? Respondent number 14D.
14D.
आपको ये लेंगे नोटिस 14D. I number 6425 of 2023 with I number 6424 of 2023. Also, the applicant has submitted that. I number that they proceed to interlocutory application has been filed for substitution of respondent number 14D, who expired on 24/3/2023, and IA number 6424 has been filed for condemnation of delay in filing the petition for substitution. He submits that the case has been pending before this court since 2009. The name of legal heirs and successors of respondent number 14D has been mentioned in
RS6.
para
6 of the limitation petition and also para 6 of the IA petition. Substitution.
paragraph 6 of the interlocutory application. Issue notice to the proposed legal heirs and successors of respondent number 14 during the contempt, whose details have been mentioned in paragraph 6 of the interlocutory application, being IA number 6425 of 2023. The notice has been directed to be issued in both the interlocutory applications. Speed post से कर दीजिए लिखित फाइल कर दीजिए। इसमें क्या substantial question of law है?
इसमें substantial question of law that was promulgated on 8/11/2012. Order number 8.
रिकॉर्ड आया हुआ इसका?
ठीक
स्पीड पोस्ट से करना? क्या
Within,
बोले थे स्पीड पोस्ट से करना?
within a week or 2 weeks.
Within a week. Post on 24th, awaiting next.
Item 14, second appeal 508 of 2016.
Substitution के लिए
किसका substitution?
plan number
Plan number?
3 and respondent 5 and 6. How for respondent 6? 6 is not.
कैसे एक पिटिशन में सारे सब्स्टिट्यूशन अप्लाई करते हैं? किसी को नोटिस जाएगा तो कैसे हम लोग इस तरह से करेंगे? ये कौन सा किस तरह का प्रैक्टिस है? और I just absolutely this makes the entire proceeding so cumbersome. है आपका लीगल ये से खोजते मैं दिमाग खराब हो जाता है। आपके पास तो फाइल नहीं है ना आज? है? कौन सा आई है यार?
10719 एक ही है
इस तरह से हम नहीं कन्वे कर सकते। इस हिसाब से मैं कोई नोट करता हूँ।
not to the
You are seeking deletion of their name. Are you seeking deletion of their name? पैराग्राफ पढ़िए तो क्या लिखा?
for deleting the name of appellant and both respondents after confirming the delay in filing of substitution application, as well as for return date outside the site and the type challenge under HSA on the basis of notice of this immediately executed civil miscellaneous case number 19/2024 against the pertinently obtained the judgment and decree passed in PS.
ये जो आप लीगल यूएस एंड सक्सेसर्स ऑफ अपिला नंबर 3 का डिटेल दिए, you have the वकालतनामा copy? You have the वकालतनामा copy? Have you filed a वकालतनामा? और रिस्पॉन्ड नंबर 8 and 9 का वकालतनामा? You don't have the वकालतनामा? सबको नोटिस कर देते हैं।
रिस्पॉन्ड नंबर 6 की तरफ से पहले से अपीयर हो रहे हैं 6 की भी ओरिजिनल प्रिंटिंग
6 का तो सब्स्टिट्यूशन 5 and 6 तो 6 has also expired ना?
No, 6 is not expired. I have filed वकालतनामा here.
Respondent number 6 has expired as per this interlocutory
I
application.
filed in 2018 when he expired.
24/1/25. देखिए IA number 10719 of 2025. This petition has been filed of 25 in SC number 508 of 2016. This petition has been filed for substitution of appellant number 3 and also for the substitution of respondent number 5 and 6. The name of legal heirs and successors of this appellant number 3 7 and 8 have been mentioned in paragraph 6, 7 and 8 respectively. The appellant number issue notice to the proposed legal heirs and successors of appellant number 3 and respondent number 5 and 6 for which requisites under speed post be filed within 2 weeks.
Appearance.
Post this case on 15th of December of 1877. उनका वकालतनामा ले लीजिए, रिस्पॉन्ड नंबर 6 का डेथ हो गया।
Item 15, second appeal 62 of 2017 this year.
Who is,
Ma'am, I have filed Wakalatnama for the respondent number 10, 11, 12 and 13.
okay,
And I have been instructed to adopt all the arguments made by the appellant member.
your senior is appearing to be seen. Now, why is it listed for orders? Only for filing Wakalatnama? Is that so, Mr. Soren? I can't hear you. The case has already been admitted for hearing. Now they are all appeared. Their appearance is complete?
Yes, yes.
The learned counsel for the appellant has submitted that notice upon respondent number
These are 10 to 13.
okay. What about 3, 5, 7 and 8?
Notice of hearing for them also.
Where is the appellant? Absent.
Leadership may see 27th March order that will reflect that. Spot number 1, 2 and 4 have been personally served.
1, 2 and 4, but there are other respondents also. 3, 5, 7 and 8. Is it a partition suit?
No, it is a title suit contested by they have lost this.
Okay. Nobody appears on behalf of the appellant. The counsel for the
Leadership, I am appearing for the appellate leadership.
Oh, yeah, sorry.
I filed
Sir.
the NOC Wakalatnama in this.
That's it. The counsel for the appellant is present as per the office note. The notice has been served upon respondent number 3, 5 and 7, 8 through the respondent number 10 and 11, with 10 through the respondent number 10 and through cousin, namely Paribha Orao and respondent number 11 respectively. Respondent number 10 to 13 has already entered appearance. The learned counsel for the appellant has submitted that. The notice may be accepted as validly served, correct?
Yes.
Considering the submissions, the notice upon the aforesaid respondents is accepted as validly served. He submits that the service of notice / appearance is complete. The matter can be fixed for final disposal. Who is the contesting respondent in this case?
All the respondent number 1 to 8.
If respondent number 1 to 8 is the contesting respondent, then how the notice can be served upon them through respondent number 10 or 11? Not possible.
Now they have been paid as a performer respondent in the matter. Earlier there was the appellate in the civil
They were
defendant in the,
They were the defendant.
yes, and thereafter the in appellate stage, the leadership may see the member of parties entity
Yes.
page number if you are reflecting only 2 appellates joined being the defendant in the first appellate court, and rest of the brothers were made as a performer respondent, respondent there. They could
No,
not
I
join.
just want to know that how the pro forma respondent will accept notice. The pro forma party hearing by the defendants.
Yes.
How they will accept notice on behalf of the plaintiffs?
No, they have not accepted this.
Yes, because you see, as per the office note, the notice upon respondent number 3 has been served through respondent number 10.
No, this should not be leadership.
We will not accept it. We take fresh steps.
We'll take steps.
You write it again. Essay number 62 of 2017. Respondent number 10 to 13 has entered appearance. Also, for the appellant is directed to take fresh steps for service of notice upon respondent number 3, 5, 7 and 8 through the concerned police station for which requisites be filed within a period of 1 week.
1 week. But
Pose this case on 1st of December awaiting service.
but
7 appeal करते हैं. 7 appeal करते हैं. 1, 2, 4, 7, 10 to 13 appeal. कौन बच गया? 3, 5 and 8. इनको कर दीजिए. 3, 5 and 8. You get that?
yes, sir. But
1st of December.
yes,
Item 16, second appeal 235 of 2018.
Also, the last order 23rd, 7 to 4 and 6.
Sorry?
This is when issued to respondent number 4 and 6, 7 and 17. Not due to insufficient address 7 and 17. And respondent number 12 appeared through wakalatnama.
4 and 6.
4 and 6, 7 and 7.
17 का क्या है?
Insufficient address. So I may take step for paper publication.
Counsel for the appellant has submitted that respondent number 4, 6 and 17 could not be served as they could not be able. 4, 6 and 17.
Insufficient.
4, 6, 7 and 17.
Yes,
The learned counsel submits that. At the request of at the prayer of the learned counsel for the appellant, 2 weeks time is
4
granted.
weeks, yes, paper publication. 4 weeks.
4 weeks time is granted to the appellant for taking appropriate steps. Through speed post, either through speed post at their present and correct address, or to file substituted a petition seeking substituted service of notice. given the update.
Item 17, second appeal 4 of 2019.
Earlier notices were issued to the respondent number 2 to 6 after admission. But there is a report with respect to respondent number 2 that the wife of respondent number 2 refused to receive notice. 3 and 5 received by their son. Respondent number 4 received by wife. Respondent number 6 and do not reside at given address. And with respect to respondent number 7, it has already been abated by the order dated 18/7/24. So at least with respect
They
to
filed a petition seeking
at least,
substitution and setting aside appeal.
it is a petition is pending with respect to respondent number 7 to set aside the abatement if any. And one another IA has been also filed for a stay of the execution proceeding, and against that I am
Where is the appellant?
against the stay petition I have to file the this
Just your name.
एडवांस स्टेज पर है वो एग्जीक्यूशन प्रोसीडिंग।
अब इसी प्रोसीड करिए, आपको क्या करना है?
हाँ वो तो चल रहा है,
चल रहा है, आप अपना प्रोसीड करिए। आप वहाँ तो कुछ कर नहीं रहे हैं, यहाँ पे
हमारा इंस्ट्रक्शन है कि इनफैक्ट पार्टली इट वाज एग्जीक्यूटेड आल्सो, सो एग्जैक्ट इंफॉर्मेशन आई हैव टू गेट।
They are not appearing.
And at least against respondent number 6 and 8 fresh notice is required, as because it is reported that they do not reside at a given address.
एग्जीक्यूशन में सब लोग अपील कर रहे हैं।
एग्जीक्यूशन में तो कर ही रहे हैं। हम रिस्पोंडेंट नंबर 1 है और वही रिस्पोंडेंट नंबर 1 ही कंटेस्टिंग है।
Respondent number 7 को कब डेथ हुआ? Where is that IA?
पहले ही फाइल ऑर्डर के टेबल
IA नंबर पूछ रहे हैं, उनका सब्स्टिट्यूशन का पिटीशन फाइल हुआ है। Give me the IA number.
IA number 7681। पारा 4 में लिखे हैं 2001 में हमारा।
They say that no substitution is required.
That's because pairs are already on the
Read करवा देते हैं, क्या IA number 7681 double appears on behalf of the appellant. This IA has been filed. Setting aside abatement.
already it is has abated by a formal order passed by this honorable और इसमें तो डिले का कोई एक्सप्लेनेशन नहीं है, बट चूंकि
ये का नहीं है, but like legal here is already on record, है ना? This interlocutory application has been filed, mentioning that the respondent number 7 has expired on 10/11/2001.
इसके हिसाब से तो अपील 19 का है, ये तो अगर ही गड़बड़ है तो अपील होने से पहले मरे।
ये नहीं अलाउड, डेथ सर्टिफिकेट भी नहीं लगाया। And his only son had expired on, and he expired on 10/11/2001, leaving behind his only son, Mohammed Mustaqim, as his legal heir, who is respondent number 8 in this appeal. Therefore, through this petition, it has been stated that क्या करें हम इसका?
मोहम्मद मुस्तकीम का नाम यहाँ पर दिख रहा है, अब टाइटल अपीलेट के कोर्ट का ऑर्डर में वो लगता है गलत लिखे। वो टाइटल अपील का जो सिविल अपील नंबर 4 है, 418, मोहम्मद मुस्तकीम का नाम।
He is already on record, ना?
हाँ, ऑलरेडी ऑन रिकॉर्ड।
कौन है इनके एडवोकेट जो आते हैं?
मिस्टर AK साहब।
सर, आप ही का केस चल रहा है। कल ऐसे 4 of 2019 post to
कल हम फसल को डॉक्टर का अपॉइंटमेंट है, उसका पैर में तकलीफ हो, एक साथ छोटी बेटी को आई है मेरे।
क्या होगा?
तो क्या हुआ ना, कुछ नहीं हुआ, उसका ब्लॉक था बचपन में, ऑपरेशन हुआ था 30 साल में। तो जो एक्सरसाइज करती थी योगा, उसमें जाम करती थी, उसी में क्रैक किया है वो। और वो ऐसा है कि छोटा छोटा चीज़ में अब वो लीव लेके खाइए, बेड रेस्ट बोला है।
इसको मेरा जैसा फ्राइडे है, इस दिन तो 4 बजे
हाँ,
फ्राइडे का
नहीं छुट्टी पर नहीं।
फ्राइडे